Hello everyone. In this video, I want to cover the Companies Act. It is a third part of the video. I have already made two parts, uh, divided company law in two parts, and that videos has already been uploaded at my YouTube channel. It is a third video. It is considered as a third part of the video, third part of the Companies Act 2013. In this video, I want to cover chapter 29, important for exam point of view, and chapter 14. That two chapters are very important for our exam, which is going to held on 11th of January 2026 with regard to the post of CBI APP, CBI APP, company prosecutor, assistant director, corporate law, assistant legal advisor, ED. Firstly, we have to know how many authorities are given under Companies Act. There are about 7 types of authorities. First is a National Company Law Tribunal, given under section 408. It is a quasi judicial body having a power of civil courts. It generally goes with the winding up or insolvency proceedings of the company. Thereafter, National Company Law Tribunal, given under section 410. It is an appellant forum hearing appeal against the NCLT or NFRA orders. Then it is a special court given under section 435 for criminal offences under Company Act. There is a one authority, registrar of company and regional director. These are two authorities which empower by the central government to time to time for the purpose of investigating, for the purpose of inquiring the matter with regard to the company, whether the company is doing a healthy sort of work within the sphere of this Company Law Act. Then there is a National Financial Reporting Authority. It is also a investigating one type of investigating unit of a central government. Section 132 provides the composition of that authority. It is a apex body of auditing and accounting standard and professional misconduct. It can debar the auditors who are working in the companies if they are not doing a work as per the act or as per the guidelines given by the central government. Then there is a serious fraud investigation office. It is also investigating unit newly established in the year 2013. Then it start workings in year 2025. 2015. That are the authorities generally who have to cover. Thereafter, I just firstly want to cover chapter 29, which says miscellaneous. The name of the chapter is miscellaneous. There are section 447 to 470, which deals with the particular situation. Basically, this chapter deals with the penalties, punishment. It also defined the word fraud under section 447, which is having a certain case laws. Firstly, I want to cover the case laws which are important. First case is Vikas Agarwal versus SFIO. Delhi High Court 2019 decided that whether a limitation is provided for complaints under Company Act. If anybody want to make a complaint with regard to the fraud, that company is doing business fraudulently, or any of the officer is doing a fraudulent act and he is not complying the act, whether a private person can file a complaint. That was the one issue. It was not decided by Delhi High Court because that issue was withdrawal by the SFIO. But the second issue was whether there is a limitation for making a complaint. The Delhi High Court said there is no bar of a limitation for initiating prosecution under this section. Under 447, there is no bar of a limitation. There is no limitation. So 447 is a broader in sense. The court said 447 is a broader in sense, applied against any person, not only against company, even applied against any person, any officer who is a part and parcel of that particular company. Generally, limitation is provided under section 433 for NCLT and NCLAT, but there is no such limitation provided for initiating a complaint of fraud against a company and officer of the company. So in this case, Honorable Delhi High Court said there is no bar of limitation. It means that any time a complaint may be filed for the purpose of seeking action against that erring officer of a company or against a company if that is not complying with the provisions of this act and committed fraud. Thereafter, second case. The name of second case is Dr. Rajesh Kumar Yaduvanshi versus SFIO. It is a case of 2020 of Supreme Court. In this case, the issue was with regard to section 129 and 448 of Company Act, because these two provisions are saying same things. These two provisions are saying same thing, that is a false statement. 129 is saying about financial statements. So if in a financial statement something a false statement is made by the person, or false record was made by the person in that financial statement, then that may be considered a offense under 448, or it is only a offense under 129 itself. That was the issue before the Supreme Court. Supreme Court said that both sections are interplay between each other. So even the offense under 129 is committed by the person, he may be liable for 448 as well, because both the sections are interplay with each other, dependent upon each other. They are playing a complementary role with each other. In this case, generally the nominee director, the proceeding against nominee director was initiated by a special court, and summon was issued against that nominee director, wherein Delhi High Court said that summon cannot be issued against that nominee director of the company because he has not committed any offense, to which Supreme Court said at the stage of summoning, High Court cannot make a mini trial, So it is always based upon the trial court whether to summon the person or not to summon a person, based upon a material fact, even though it is a nominee director of that company. Still, special court has a power, because at the stage of summoning it cannot be decided the facts which came during trial. So at the stage of summoning, High Court cannot conduct a mini trial. Supreme Court said this. So nominee director is liable for adjudication, or against whom certain type of false statement allegations were made. That actually Dr. Rajesh Kumar Yaduvanshi was a nominee director of PNB at that time. Punjab National Bank. And that director, nominee director, was also a board member in Bhushan Steel Limited at that time. Bhushan Steel Limited. And one statement was made with regard to PNB company, and the nominee director was summoned by special court with regard to that false statement. And a special court framed a charge against that person under 448 because the financial statement, as per the financial statement of that company under 129, that would attract a false statement charge under 448, and that is why the summon was issued against that nominee director, which the Supreme Court suggests it is a good proceeding conducted by the special court, and the order of Delhi High Court was done away. That is the second case. And now there is a third case, Union of India versus Deloitte Haskins and Sells LLP, 2025 Supreme Court. In this case, there was an issue before the Supreme Court with regard to double jeopardy. Supreme Court said there are two provisions under Company Law Act. One is 140 clause 5 and other is 447, which talks about fraud, and 140 clause 5 talk about the auditor. If auditor is not complying with the provision of this act, then he has to give up his office, he has to give up his post, and if he is not complying with the directions of the central government or complying with the directions of the NCLT, then he may be liable fraud also. So the issue before the Supreme Court was whether the proceeding initiating under 140 clause 5, the proviso, if already been initiated against that auditor, then can a proceeding under 447 may also be initiated against that person? The Supreme Court said that it can be happened because two provisions are giving fruits there within their own sphere. So even though 145, a second proviso, the provision with regard to 447 is already mentioned that if auditor is not complying with the provision of this act or committed any wrong while working as an auditor in the company, he may be liable for fraud, which is already given under 140 clause 5, a second proviso. So in that case, it is not a proceeding that is to be initiated in a parallel way on a same facts. It is a proceeding that certain wrong has committed by that auditor, then proceeding initiated under 140 clause 5, and that act may be considered as a fraud or not. That may be a question of a fact. If that is a fraud, then 447 may be attracted, and both the provisions are giving a fruit to their own sphere, that not be considered as a double jeopardy. That is decided by the Supreme Court. Thereafter, the issue which is very necessary to understand here, let's suppose 447 talks about fraud. So whether for the purpose of a fraud in a company, let's suppose it is a company is committing a fraud with any person, or officer of that company committing a fraud with the outside of that company with regard to the third person. A third person can file a complaint of a fraud against that company or against that officer of that company. That was the issue. So there are two high court judgment which says no private complaint or prosecution can be initiated against a company and against an officer of the company. Prosecution has to be launched by only SFIO, Special Fraud Investigation uh, Agency, or authorized officer, which is authorized by the central government after formal investigation. So if anybody want to file a complaint, they have to file a complaint at the office of SFIO or at the office of authorized person who was authorized by the central government. Then only SFIO or that authorized person can initiate the investigation on the basis of that facts, and if SFIO or authorized person find that the company or the officer of the company committed some kind of fraud, then they can initiate a process or a process by making a complaint before central government or complaint against that officer or a company to special court so as to initiate the proceedings for 447. That is all about these cases, and there are two cases of two high court. One case is Samana Parachuri versus Jakka Vinod Kumar Reddy, that is decided in the year 2022 by Telangana High Court. And second is Arun Balakar versus M. Krishna Reddy, that is the latest case of Karnataka High Court. Karnataka High Court 2025. In this case, in both the said cases, the issue was the same, whether the private complaint or prosecution may be initiated against the company with regard to fraud or officer of that company with regard to that fraud. So, who have already done the case laws, so I just want to start with the definition of a fraud. Section 447 states the fraud. We have already section 17 of Contract Act, which is also defined the term fraud. What is the difference between 447 and section 17 of Indian Contract Act? Indian Contract Act section 70 talk about fraud. It is deal with only one kind of fraud, that any act intended by the person against other party so that other party can enter into contract. So the area of a fraud is very narrow in sense. A want B to make a contract with him, and he is making a fraud with B by suppressing some facts or by not disclosing certain facts which are necessary to disclose at that time, or he is silent at that time wherein he was having a duty to disclose that facts. That may be considered as a fraud, and because that contract was made without a free consent of B, it may be considered as a voidable contract. But 447 having a broader idea, it says that it qualified two things. Firstly, quantity of money was siphoned off by the person. Second, whether there is a public interest involved in this case. If there is a public interest, let's suppose there is one company dealing with the public interest and one of the employee of that company committed a fraud, or that company itself uses that funds which has to be used against the welfare of the persons, that may be considered as a fraud against public interest. And second is the quantity of money, whether a person against whom the complaint of fraud is to be initiated has committed a fraud of at least 10 lakh or 1% of a turnover of the company, whichever is the lower amount. If that was the quantity of money involved in this case, then the punishment may be given at least 6 months. In first case, at least 6 months, which may be extended to 10 years. And fine, having option, whatever you have defrauded, you may be fined with that money or 3 times to that defrauded money. Let's suppose if the fraud in question involves a public interest, then in that case a minimum 3-year punishment may be given to the concerned person, which may extend to 10 years. If does not have a involvement of public interest and amount of money does not have a public interest and amount of money is also less than 10 lakh or less than 1% of turnover, then that person may be guilty of up to 5 years, or fine which may extend to 50 lakh or both. So only fine may be imposed against that person and imprisonment may be given to that person up to 5 years. So in that fraud, 447 fraud under company law, there is one issue, there are two issues. First is quantity of money involved which is defrauded. Second is a public interest. But in section 17 there is no such distinguish between a public fraud or a private fraud. It is a fraud with regard to free consent. It only vitiates the free consent of the party, one of the party to the contract. It generally deal with that. It is a narrow sense of a fraud. Quantity of money is not an issue under Indian Contract Act section 17, but here is the always a issue. So that two ways are the things which are considered for the fraud under company law. So what is a fraud? It is not defined under 447 a section, but it is defined under explanation. Explanation 1, that what is a fraud? What is to be considered as a fraud for the purpose of 447? It says a fraud in relation to the affairs of the company or a body corporate. There are two ways: fraud in relation to the affairs of the company, fraud in relation to the affairs of the any body corporate. There are 4 ways by which it may be considered as a fraud. 4 ways. First is any act, any omission, any concealment of any fact, or abuse of a position. Abuse of a position committed by any person. Committed by any person or in connivance with that person. It may be outsider, and that outsider with the connivance of the official of that company or the company itself or the director of the company, of any person who is an employee of that company. Connivance of that person with the intent to deceive, or with intent to deceive to gain. First purpose is to gain. Why intended to deceive? Because he want to take a gain. Or injure to interest. There are four types of interest involved in this fraud. Four types of fraud. Four types of interest, sorry. One is the interest of a company, interest of a shareholder, interest of a creditor, and interest of a other person generally dealing with that company. So you are injuring the interest of that person by abuse of position, by concealment, by omission, by act committed by you with the intent to deceive that person so as to gain. You have a two options, to gain or to injure the interest, and that to gain undue advantage. What type of undue advantage? That it may consider you may take a wrongful gain, or you may take a wrongful loss. You may commit a wrongful loss against that person. That is the way to understand this definition and the punishment. Wrongful gain and wrongful loss is also defined in explanation second and explanation third, which is a same, which is we have already covered under BNS or IPC. Thereafter 448 section is important. 448 section only define false statement. Define false statement. It does not provide the punishment. Does not provide the punishment. For the punishment purpose, we have to follow 447. So false statement may be considered as a fraud under 447. So false statement is not a offense, but the punishment same provided for fraud, and that statement if a false then may be covered as a fraud. If any person making a statement which he knows it is a false statement, he knows it is a false statement, or he omitted to give any statement where he is duty bound to make a statement on a material fact, in any return, in any report, in any certificate, in any document, in any financial statement, prospectus, anything, other documents which are required under this act or under any rule, but he is giving a false statement, knowingly it is a false, he is omitting to make a statement on a material fact, it may be considered as a false statement, and that false statement is an offense under section 447, may be considered as a punishment for 447. So 449 provides the punishment of false evidence. Generally, whenever the person come before the court or any tribunal, he has to take an oath, he had to take a affirmation that I will going to state a true facts, whatever I know, whatever I have information, I will state a true fact. Now if he is giving a false evidence, there is always a duty within itself, no false evidence, but you giving a false evidence. 449 so as to remember this section. This is the only way that we can understand that the false evidence is an offense under 449. No, you must not give a false evidence. You are intentionally giving a false evidence upon any information or in any affidavit after taking an oath or solemn affirmation about any matter or about winding up, about anything or about winding up, it is may be considered as a false evidence, and the punishment is provided 3 years to 7 years and fine up to 10 lakh. 9, 10, 4, 3. Thereafter, section 450. 450 is a general section. We have already done the types of the authorities given under company law. There are 7 types of authority. There are registrar, there is a regional director. These 2 authorities can also imprison a person. They are considered as a civil court. All the civil court having a power may exercise by that officers under company law. They can imprison a person for a purpose if any officer of the company or company is not complying with the provision of this act or not complying with the order of registrar or regional director, they may be imprisoned for 6 months, up to 6 months. If that is decided by registrar, you can file an appeal against that registrar to the office of regional director. That is the way you can take a view with regard to the proceedings under Company Act. Section 450 talks about debt contravention. If any officer of the company has not taking care of any rule or contravene any provision of this act or any rule or any condition, restriction. Let's suppose there is a certain type of approval or sanction or consent or confirmation or recognition need to be done by the company, but they have not done. There is a contravention. Now the fine may be imposed against that company or that officer at 10,000 rupees. That is provided under 450. 549 9110. And if that fine is to be imposed against that person, against that company, still that contravention is still continue, then 1,000 rupees a per day fine may be imposed against that person, a maximum to 2 lakh against a company, and maximum of 50,000 against that officer of that company. So always follow the guidelines, always follow the rules, always follow the acts, always follow the provision of this act. If you are not following, then 450 may be attracted, because there is no specific penalty or punishment provided under that contravention under a Company Act. Then only 450 may come into play. Otherwise, that particular section which are provided the specific punishment, specific penalty can be used. Thereafter, 451. 451 says punishment of a case of repeated, you are making a default at once. Thereafter, again you are doing a repeated task of default. Again repeated defaults within a period of 3 years. 3 years is you are making default once, punishment is imposed upon you, being a company, being an officer of the company. Thereafter, within 3 years, you again committed that default. Now again you have committed that offense. Now the punishment, the fine may be imposed against that company, that officer, erring officer. Now the twice of a fine imposed given under this section, twice. That is section 451 says. In addition to the punishment for that offense, that may be imprisonment or that may be anything else, twice whatever the fine is given, now the twice of that fine may be imposed against that company or that officer. Thereafter, 452. 452 says that nobody having a authority to withhold a wrongful property, wrongfully holding property. So the property is belongs to somebody else. Any company, any officer of the company, any employee of the company wrongfully holding that property, it may be considered as a corruption. And that is why 452 is made, which says that a court may impose a fine from 1 lakh to 5 lakh. Firstly, whenever the complaint is initiated against that person with regard to that default, that wrong act, firstly court will ensure that order to refund within a time bound that amount, that property to the concerned person who is a owner of that property, owner of that money. Firstly, the order must be returning order, and that if the return has not made within a certain specific time provided by the court, then in case of that default, up to 2-year punishment may be imposed against that officer of the company, against the company of the against the company. That is all about 452. Thereafter 453. 453 says that nobody is having authority to use a name generally given by the central government, given by the registrar, given by the company under Company Act provisions to particular company by complying that procedure. Like private company is considered as a private company limited or limited world. If anybody without complying, without authority is using that name, it is considered as an offense under section 453, and a fine may be imposed against that person up to 5,000 rupees. And if fine has already been imposed, still the person is wrongfully using that name, a 2,000 rupees per day fine may be imposed against that person. And the adjudicating authority for all purposes of the fine to be imposed against that concerned person is provided under 454. That adjudicating authority is a registrar. I have already defined the word registrar. Registrar has to be appointed by the central government, and appeal may be against the order of that registrar to the office of regional director. So appeal to be within 60 days, and if a company not complying the order of the registrar within 90 days, 90 days is given to the said company or said hearing officer to complying with the direction of that registrar or regional director. If not complying, then a fine may be imposed against that person to 25,000 to 5 lakh rupees. And said hearing officer may be imprisoned for 6 months, or a fine may be imposed against that person of 25,000 to 1 lakh. 25,000 to 5 lakh can be imposed against a company, and 25,000 to 1 lakh can be imposed against that hearing officer of that company. That is the way that you can finish these provisions till 454. So we have to cover chapter 14 also. Chapter 14 also. Chapter 14 having up certain case laws which are to be understand, and there is some provision which are to be understand, because in a company law, if authority or employee or a company or officer of the company is not complying the procedure under a company act, then the investigation, inquiry, etc. may be conducted by the central government through registrar, regional director, or through SFIOs. Chapter 14 talks about that investigation. It covers inspection may be done, inquiry may be done, investigation may be done. Section 206 to 229 deals with all situation. So there are central government, a registrar of companies to oversee the corporate transparency and prevent fraudulent activities. So whenever any company is doing business in within India, so it is being a directive principle of a state policy of a central government, has to follow certain guidelines, has to ensure that particular company has to do a function within the sphere of Company Act 2013. First, section 206, it says that the registrar of companies and the central government to assess the corporate health of the company through information gathering, inspection and inquiries. So 206 is a general provision which says a regulatory approach of registrar of the companies. They can request specific information or document from the company, inspect that documents. If there is an unsatisfactory book or account book or document, then inquiry may be initiated with regard to that fraud, because 447 cover it is a fraud. False statement may be considered as an offense under 447. So formal inquiry may be conducted if a registrar of a company suspect that business is operating for fraudulent purpose, and the opportunity to the company may be given, and the government also directed inspection if anybody file a complaint to particular department that that company is not doing business as per this act, he is doing activities which is not authorized under this act, then that department may initiate the inspection through registrar of companies, or central government can authorize an inspection through circumstances necessitate through inspector. Central government may appoint inspector for that purpose. Registrar of companies are already is there, taking care of all things with regard to the company law. And if the person is not compliance with regard to providing information, with regard to providing documents or anything which the registrar of companies or inspector generally need for the purpose of inspection, for the purpose of inquiry, and that company, that hearing officer is not providing, then it may be considered as a non-compliance and result into fine up to 1 lakh with additional daily penalty of 500 rupees for continued failure. There is a case law, Kervi Stock Broking Limited versus Union of India of Telangana High Court. It says that 206 clause 4 require a report to be submitted only after granting the company a fair opportunity to be heard. It clarified that the investigative steps under 212, so SFIO is conducting investigation under 212, and the investigation of SFIO is totally dependent upon the procedure given under 206 to 208. So firstly, SFIO must ensure the process under 206 to 208 has to be complied for the purpose of investigation with regard to the fraud or other bad activities conducted by the company or erring officer under this act. So right to hear also be given to that company. Inquiry of a fraud under 206 clause 4 is a prima facie necessary condition. Parallel proceeding of registrar of company is not barred if the SFIO is also conducting investigation. ROC also can take a further information if a new factor came into the knowledge of ROC. There are procedural requirements. If that procedural requirements are not followed, then that may be considered as arbitrary, because the procedure given under 206 to 208 is a procedure established by law. It has to be followed while making investigation under 212 by SFIO. If SFIO is not complying the provision 206 to 208, then that investigation may be quashed by the High Court or the Supreme Court. 207. It is a conduct of a inspection and inquiry. It is a part of 206 to 208. And in that case, a director and officer of that company has to produce the documents to the registrar of company and inspector, because they both are enjoying a civil court power. They can examine a person on oath, summoning a person. So 207 is talk about a conduct of inspection and inquiry. So there are some duty imposed upon that erring officers or a company, that director, officer of the employee are legally obligated to produce all required books of the account and documents, because that registrar of the companies, or that inspector having a power of civil courts, they can also impose the penalties. There is one case law, HV Jayaram versus ICI 1999 Supreme Court. It says, let's suppose there is one company having a branch offices in throughout India. If any branch, some wrong is committed by that company in his branch office or his that office, then where the offense is to be considered as a committed. This case says the jurisdiction where the place of registered office is situated may be considered as a place of offense. That is maybe that place where the is registered office is situated of that company may be considered as a place where the offense is to be committed. Thereafter 208, that is inspection report. Inspector must submit a written report to central government. So 208 is talk about dependent upon 206 and 207. 207 talks about inspection etc., inquiry etc., and their report has to be submitted to the central government under 208. And when the inspection and inquiry or registrar or inspector written report to the central government, then central government recommended the investigation under 208. 209 talk about search and seizure of ROC and inspector. They have a power as like a civil court, but there must be some evidence of reason to believe that a reasonable ground to believe that books or paper are likely to be destroyed by a company, mutilated by the company, altered or falsified by the company. They may apply to special court for search and seizure. They need a warrant for search and seizure under 209. They can approach to the special court basis upon certain reason to believe that a company is going to destroy document, mutilated, altered document. Upon said judicial authorization, they can enter any place to so as to seize the documents. Thereafter 210, that is investigation. Investigation is ordered by central government into the company affairs, on a basis of a register of company report, or on the basis of a special resolution, or on the basis of a public interest. So 210 is based upon three things. If central government want to make an order of investigation with regard to the affairs of the company, firstly he must have a report under 208, and that report is based upon certain facts investigated, inspected, inquired by that registrar or that inspector. On the basis of that report, on the intimation of special resolution passed by that company, or in the case of public interest, then only investigation to be ordered by the central government. And for investigation, appointment of special inspectors may be done by the central government, and thereafter investigation also be given to SFIO. 211 talks about the establishment, the office of SFIO, that is a joint secretary level officer may be considered as a director of that SFIO unit. Thereafter, multidisciplinary organization to investigate the complex corporate frauds led by the director, not below the rank of joint secretary of the central government, having experience of corporate affairs, and their staff by expert in banking, corporate affairs, taxation, forensic audit, law and information technology. So for the purpose of investigation under 211 clause 6, there must be reason to believe in a writing before assistant director. So sorry, if they want to arrest somebody, in 211 clause 6, the arrest power is given to SFIO assistant director, not below the rank of assistant director, but that has to be on a reason to believe, and that reason to believe based upon certain material, and that information is to be in writing, that person is guilty of fraud, then assistant director can arrest that person then and there, and within 24 hours it has to be produced before a special court or a judicial magistrate first class. So firstly, judicial magistrate first class give a PC remand to the assistant director SFIO with regard to that person for 15 days only. For that was covered under 167 CRPC, but now it is changed under BNSS 187, which says within 60 days, that first 14 days the remand may be given to the person, to the authorities. If the investigation with regard to, because the investigation as per the punishment is to be conducted within 60 days, if the arrest is to made by the person, if accused is arrested, then within 60 days charge sheet has to be filed, because 60 days as per the punishment 60 days is prescribed. So within initial 14 days, the 15 days remand may be given to SFIO assistant director if court finds the reason for the same, and that may be provided by the judicial magistrate first class. First production always before a judicial magistrate first class, and if in a first, when the production was made at a first time, then a judicial magistrate first class can provide a judicial remand or a police custody. If the remand is not given to the SFIO and person may put into the judicial custody, in a second time only special court can give a police remand. So first production must be before a judicial magistrate first class, and second and further on production must be before a special court. So whenever arrest to be made under 212. So firstly, the intimation to SFIO office must be outrightly, and the SFIO probe is totally based upon the report of the registrar or inspector or special resolution by the company or request form from the government department or in a public interest. Then only 208 or 2010 are two sections upon which the investigation power given to the SFIO under section 212. Exclusive jurisdiction assigned to SFIO. No other investigation agency can proceed with the investigation of the same offence under Company Act. 212 clause 6 is a very mandatory in sense, which says twin condition of a bail. No anticipatory bail may be granted to the person. 212 clause 6 prohibit for the same. If a person want to get anticipatory bail, he has to prove at the stage of bail that firstly the prosecutor must be heard by the court. Second, court must be satisfied that accused is likely not guilty, or he may not be committed a second again offence if given that bail. That two facts has to be put before the court, then only anticipatory bail or any bail may be granted to the concerned accused person. So 212 clause 6 defines a twin condition of a bail, which is also provided under PMLA, which is also provided under NDPS Act. There are certain cases, SFIO versus Rahul Modi. It says that 212 clause 3, whenever the investigation order is given by the central government to complete the investigation within a time bound manner, and that time is already elapsed through SFIO. SFIO could not complete the investigation within that time period. Whether after that period, whether the accused may approach to the court to quash that investigation. Supreme Court said no. 212 clause 3 is a directory, not a mandatory. So investigation does not become illegal simply because it exceeds the initial stipulated period. There is a second case, SFIO versus Sahara Housing Investment Corporation Limited. It reaffirmed the court should not stay SFIO investigation at an interlocutory stage unless there is extraordinary circumstances, emphasizing that the purpose of such a probe is to unearth complex frauds. Third case is SFIO versus Nitin Johri. Court cancelled the bail granted by the High Court, ruling that economic offences constituted a class apart and require a more stringent approach to the bail. So twin condition has to be satisfied before granting a bail. 213 says that the power of NCLT can also make an investigation through any agency like SFIOs or inspector appointed by the central government. Generally the inspector, not the SFIOs. So when NCLT can investigate, can pass order of investigation whenever the shareholders make an application before NCLT. At least 100 member or a member holding 1/10 of total voting power make an application before NCLT, or evidence of a fraud or misconduct came into the knowledge of NCLT through inspector or through central government, then the NCLT may order the investigation. But NCLT, before granting that order, has to summon the concerned company, concerned person, and hear that company. But in 212, SFIO started the investigation on the order of a uh, on a compliance of a order of a central government or resolution passed or something whatever given under 212. But NCLT has to hear the concerned company, concerned person before making that order. Requirement of hearing we have already done. Prima facie case of fraud or misconduct has to be established. Thereafter 214, security for a cost. It says whenever the investigation to be ordered by the central government through SFIO, that investigation has to be conducted by SFIO, central government may impose a security against that person who want to make an investigation, who want to make an order of investigation from central government passed in favor of SFIO. 25,000 may be get from central government from that concerned person. Thereafter 215, a person can be appointed as an inspector, individual, not a firm or body corporate, for the purpose of investigation. 216 is investigation in a narrow sense. It determines the true owner, who is the owner of that company. That investigation is covered under 216. 217 says inspector's power, that we have already done. Inspector is also considered as a civil court. So 217 says whenever the order is given by the inspector to examine any person, summon or demand production of any document, so other person or other company have a duty to cooperate with the orders of inspector. Third party info can also be get by the inspector, and his power to investigate as a civil court authority, examination on oath, a civil court power, all the things that a civil court can do can be done by the inspector. Custody of a document, he may take a custody of a document and remain in that custody for 180 days, and must return that document to the company after a lapse of 180 days. Extension may be get by that inspector. If he want to get custody of additional 180 days, he has to file a written order. He has to give a written order with regard to it, and that the evidence which examined by the registrar, that inspector, may be considered as a legal evidence. So if the concerned company or concerned person is not complying with that order of the registrar or order of the inspector, then imprisonment may be imposed upon that concerned company or person of 6 months, or fine at 25 to 1 lakh rupees, and continued failure 2,000 rupees per day. Whenever there is a order against that director with regard to that default, then that director or officer is convicted, then it may be deemed to have vacated their office and disqualified from holding office. And letter of request and reciprocal aid is same as provided under BNSS, that if the company is located outside, then Indian courts can issue a letter of request to the foreign authority to give together evidence against that company. It is the same way the other foreign countries can also take the assistance from the court in India to make an investigation with regard to any company which is Indian company and doing a business at a foreign country. 218 talks about employee protection. It says when the investigation is pending, no dismissal or punishment may be against any employee of that company against whom the investigation is pending. Core restrictions. So investigation under 210, 212 or 213 is active. Person cannot take a following action against that employee without prior approval of NCLT. NCLT can give a direction that action may be taken against that employee. Company cannot discharge or suspend that employee, punish that employee, change the term of employee. Approval timeline is given if that company want to initiate a prosecution and want to suspend that person or anything, any fine imposed against that person at employee, he has to file before NCLT. If NCLT has not given order within 30 days of that application, then companies may be permitted to proceed with the proposed action, and the order of NCLT may be challenged before a National Company Law Appellant Tribunal NCLAT within 30 days. Thereafter, two types of investigation who have done this chapter. But we have to done types of investigation under this whole chapter. First, provided under 210, which is a central government by inspector, and it is a general probe against the company affairs. Second investigation is provided under 212, which is a central government through SFIO against serious or complex fraud. Third is NCLT and a member of NCLT through central government appointed inspector may be investigated against a fraud operation or withholding info by the company. In 216, central government or NCLT may order investigation. NCLT may ask the CGI appointed inspector to investigate the fact regarding identifying the true owner or controller. 219 talks about the existing inspector regarding the affair of related subsidiary companies, whether there is a subsidiary companies of that company against whom the investigation is pending. 299 says that inspector may investigate that fact under 219, that 219 empower that inspector. 220 talks about a seizure of document by the inspectors. Power of inspector to seize the documents during investigation till investigation, completion of investigation, so that destroy, mutilated, altered, falsified cannot be done. 221 says freezing of assets of the company by NCLT. NCLT can freeze any asset up to 3 years on inquiry or investigation, but that freezing order has to be given on the basis of reference by the central government or inquiry or investigation under this chapter, or on a complaint number of member in section 244 clause 1, or creditor may also approach to NCLT so as to get a order of freezing of asset if that creditor have a outstanding of 1 lakh against that company or any person having a reasonable ground that removal or transfer or disposal of funds, assets or property company likely to take place. It is just like order 39 we can say under CPC, which says about the injunction order. It may be considered as an injunction that freezing of that assets of the company. 222 says securities restrictions. NCLT may impose restriction on the transfer or voting rights of the securities on a pending investigation, and that restriction may be imposed for the purpose not exceeding 3 years. 3 years, no transfer or voting right of a securities. If that default done, then a fine may be imposed against that company 1 lakh to 25 against default employee. In that default employee may also be imprisoned for 6 months or a fine up to 25,000 to 5 lakh or both. 223 talks about the inspector's report. Inspector report has to be given to the central government and action on the basis of that report under section 224, central government can initiate prosecution by winding up the company or recover damages based upon the report. Need not to be file anything or take order from a special court or NCLT. Central government straightforwardly make a initiation of prosecution through SFIO, or winding of order may be given with regard to that company through registrar, or recover damages based upon the report. 225 says cost of investigation has to be beared by the applicant who want to take order of investigation, or by the company itself. 226 says the winding up no bar, voluntarily winding up does not bar stop the investigation proceedings. Both the parallel proceedings may be initiated. 227 says there is a privileged communication by legal advisor and banker of that company are not required to disclose certain confidential client information, privileged communication to tribunal, to central government, to registrar, or to inspector. So all the procedure. 228 says that a foreign company, these sections applies also to the foreign company operating in India, the same procedure. 229 says the penalty for the fraud, if false statement, destruction or mutilation of document, all are offense under section 447, that is fraud. We have already done that concept. That is all about chapter 4 and chapter 29. It is a third video of Company Law Act. I will make a fourth video as well. We have one topic left, that is about NCLT, that is about NCLAT, special court, and certain part of other area like 73 to 76A section. I will complete in fourth video, and after fourth video the Company Law Act may be completed. Thank you so much.